So that the church existed separately from the bishops and clergy and laity. 2, the property of the corporate person is distinct from the property of its members. So if the church had land, the land was for the church and not the bishop. If the group of people acquired a bus, it was for the group and not the leader. And then the property of members could not be taken in execution of the debt of the corporate entity and vice versa. And so if I'm a member of a group and the group has bought a bus and I separately enter into a transaction with you and default and you sue me, you can only sell my assets. You cannot attach the assets of the corporate body of which I'm a member. Now these rules began in the 13th century. The people who really escalated this concept of the corporate entity were the borrowers and the merchant class. By the 13th century, boroughs, which let's call them districts, but for the sake of Ghana, were granted franchises through a royal charter so that the king will grant this borough a franchise. And that franchise to form what we may call the district included limited powers of self-government. You see that in companies now. The right to elect governing officers, the right to perpetual succession, which meant that, let's call it the district, survived its members. The fact that the district chief executive dies does not mean that the district disappears. So its life survived that of its members. They soon had the right to sue and be sued in the group name, the power to hold land, use a common seal. All of these, which evolved from the formation of the boroughs, are now principles of company law and have formed the cornerstone of what has become known as corporate governance. So we just didn't arrive here. There are hundreds of years of history. There's hundreds of years of history behind these rules. But like I said, the movers and shakers were the merchant class. By the 14th century, they began to realize that you couldn't do it alone. And so let's say in the city of Accra, I am a leather tanner. I produce a lot of leather. You produce a lot of thread. He produces a lot of plastic. And he or she is a good maker of shoes. So we come together, the four of us. I bring my leather, you bring your thread, he brings his plastic, she brings her skill in making shoes. We value what everybody has brought and agree that based on the value, this is my interest or this is my share. That's the evolution of the concept of shares in the entity. So that if the entity is 100%, maybe mine is 20%, yours is 60%, etc., etc. We decide that this is how much everybody has brought in. Now, you, the one who's going to make the shoes, we will value your what became known as sweat shares, sweat equity, because I only bring my leather. You actually make them without bringing anything tangible. So we will value your work. And then your share in the business will be the value of your work. Now, once I have put my leather in the business, I no longer own it. The business owns the leather. When the shoes are made, they are not mine. They don't belong to any of us. It belongs to the business. Now, we need to move from the district of Accra to sell in the district of Adan. And so the company of us, as we accompany each other, will go and sell. When we make money, we come back and sit down, and then in accordance with our agreements, we'll say, let's leave this for the next venture. But we have made profit of this amount. We will divide that profit. That's the root of the word dividend. You are beginning to see where we're coming from. Am I boring you with the history? I hope so. Now, we will divide the profit in accordance with our share in the business. So if my share was 40% and there was 100 cedis to be shared, I took my 100 cedis. But 40 cedis. Thank you, the mathematicians are here. But we would have left some of the money for the next venture so that we don't always have to produce. So very soon, the entity starts acquiring its own leather, starts acquiring its own thread, its own plastic to make the soles. They hire more people to make the shoes. The company of us is growing. This is the root of the formation of the word company. But after a while, it was and trust me, this was the turning in the economy of what became known as the United Kingdom. Soon, business began to grow because there is a natural growth when people work together. Unfortunately, so business began to grow beyond provincial interest, and the merchant guild began to seek interest over wider geographical regions because they made all the money from shoes. So they decided it's time to go into rum. Let's import it from France. It's time to go into this. Let's import it from this other place. Part of the story is a bit unfortunate because the growth in company law coincided with the growth of slave trade. It was well nigh impossible for any single man to rent a ship, hire people with guns and chains, and ship people, come all the way to Africa, arrest us, send us all the way to America, and sell us. And so the concept of the charter corporation began, where now they will go to the royal themselves and seek what is called the royal charter. And on the basis of the contributing shares, that you got the guns, you have the metal shackles, you own the ship, you hire the people. What is the value? The royalty, the kingship or queenship of England will give them a royal charter to come here and arrest us and sell us. It is from the rules, these rules, unfortunately, that the concept of corporate governance has emerged. Now let me get controversial. Unfortunately for us in Ghana, it does not appear that our traditional business practices involved the evolution of the corporate entity. Yes, we had the concept of the corporate entity. The Ebusia was a group of people. And so the Asuna Ebusia could enter into transactions or could have a representative in the king's palace or the chief's palace. Now, you don't know whether we should say king or chief. I believe that the concept of Ohin is neither king nor chief. It's probably even bigger, but that's another story. But you will struggle to find the corporate merging of business undertakings in our traditional society. Our ancestors were farmers, fisherfolk, hunters, gatherers, traders, etc. The idea that a number of farmers will merge their lands into a separate entity and value the lands and farm the lands together and share or divide from shares did not really evolve in Ghana. The land was for you. Most of the fights were over the boundary of the land, making sure that we keep the other person away from the land. So we have traditional trees which were used to mark boundaries. And it was said that you do not use plantain to mark boundaries because plantain trees tend to shift. You know, once you plant one, others will begin to grow along it. So we were more interested in protecting what we have as against merging what we had together to create that accretion of capital. In certain areas, the concept of Ebunu and Ebusa came in. But you must understand that yes, we could have emerged, a corporate person could have emerged from that. But that was really regulating tenant farmers. So that if somebody came from outside your tribe and wants to farm your land, you agree that we will divide the profit into 2 or 3 and I get half or 1/3 or 2/3. So that concept existed. But the merger of undertakings into another entity, so we shared the profits, did not really gain root. And let me add that when the colonialists came here, they made sure that we did not put it together. Because had we put these together, we would have kicked them out of Ghana much earlier because we would have had money. It would have taken 100 years for us to kick them out of here. Somehow, this has pervaded. This probably informs our sheer inability or unwillingness to comply with rules of corporate governance. Captains of industry are repeatedly found out as persons with feet of clay. The clay being the part that simply ignores the rules and treats both the company and its assets as an extension of the founder or proprietor. It probably explains why several potential Ghanaian conglomerates peter out when the founder dies. Because the successors, forgetting that the company was the one doing the work and not necessarily the founder, will feast on the assets of the company. If the company has buses, once the man or woman dies, the children get up, divide the buses. Now, because the buses are not working together and running solo, they get spoiled. And that's the end of it. The business is dead. I'm saying that several businesses that could have become conglomerates, big conglomerates in this country, never survived the lives of the founders because we did not appreciate and apply the rules on corporate governance. Has it ever occurred to you that Hewlett-Packard is actually a certain Hewlett and a certain Packard who made the undertakings? Now, what do you care? You get their machines. And HP is great. But it is Hewlett and Packard. Do you even care to find out whether Lever brothers were brothers or sisters? Because if you build the corporate body and you allow the rules to work, it acquires its own goodwill, which will survive you. Now, the inability of our inability to let go, to let the business run by its own, is part of the problem. That is why you're driving the vehicle that belongs to the company, and you say, "My car nebano." It's not your car; it's the company's car. If you want my car, buy yours. So the company's car takes you from work home. It goes to the market. It takes your children to school. In a very short time, the company's car is dead, and you get another one in the company's name. Now, with the death of the proprietor, the founder, the company has no defender. It is feasted upon and it dies. So we move to the next level, which is the corporate existence and corporate governance. That the rules upon incorporation remain largely based on the foundation laid in the 13th century. Incorporation allows the company's property to be clearly distinguished from that of its members. Members have no proprietary right over the company's property. Can I say that again? You have no proprietary right over the company's property. You cannot simply dip your hands in the company's money. I don't care whether you are the 100% shareholder or not. The rules are that as a shareholder, you are only entitled to the dividend, what is divided in accordance with your shares. The rules are simple. You cannot pay money as dividend when the company has not made profit. So the law says that dividends are paid out of the income surplus account. And even if there's profit, it must go to the board. And the board must look at the needs of the company going forward to decide that maybe we want to keep this part and now we will declare dividend at this amount of money per share. Then in accordance with your percentage, you take your money home. That's all you're entitled to. If you want more money, sell your shares. Newsflash, the company is under no obligation to buy your shares if you say you want to sell. As I said, it's not like you own the football that everybody is playing. And when your team is being defeated, no, watch your ball, put it under your armpit. So if we decide to put monies together into a company and you feel that you are not getting what you want, if you want to leave, take the shares. You can't resign as a shareholder. It's not really a position. It just means you hold something, you own something. That's it. So if you want to leave the company, you have to sell your shares. If the shareholders like, and based on rights of preemption, which is something else, they might decide to purchase it from you. If they don't like it, you have to sell it elsewhere. Now listen, a company cannot even buy its own shares except under certain very strict circumstances. Yes. So you see how much you are breaching the law? Every distribution to members is either prohibited or made subject to the approval of the court. The company's assets are not distributed upon the death of any shareholder or withdrawal. I'm going, so let's share the assets. I've seen some people come to my office. I don't like what they are doing in the company. They are cheating me. So I contributed a car and trotro. I want to take them out. You can't. Your car and trotro have been converted into shares. When you decide that you want to leave, what you have is your shares. If you don't have anywhere to sell it, you remain a shareholder. If you don't like the paper, the share certificate, you can shred it and throw it away. You are still a shareholder. Your name is in the register of members. And it's not as if Ghana law has lagged behind. Let's talk back to 1978. Barclays Bank and Latte. The court held that the true intent and spirit of the act, the Companies Act, is that the company, once incorporated, acquires a legal entity distinct from its members, even if it has only one member. The company enjoys perpetual succession. I've explained that. It can sue and be sued in its name. It can own property distinct from that of its members. The provisions of the Act make it abundantly clear that once incorporated, all matters relating to the affairs of the company are dealt with in the name of the company. This is Ghana law, a decision by a Ghanaian court. And so corporate governance in modern terms refers to the system of rules and practices and processes by which a corporate body is directed and controlled. It involves balancing the interests of a company, its stakeholders such as shareholders, management, customers, suppliers, financiers, even the government, even the community. It encompasses practically every sphere of management, from action plans and internal controls to performance measurement, corporate disclosures, basically the whole gamut of rules that govern this entity that we call the company, which we don't seem to understand. So that's really my introduction. So we are getting to the issue about the corporate curtain. There are various terms, lifting the veil, piercing the cloak, looking behind the curtain. A story is told in the Bible of a young man called Jacob who saw a woman he wanted to marry. And when he asked the father of the woman to marry her, he said, "You have to work for me for 7 years." And this man worked for the woman for 7 years. 7 years hard labor for the price of a woman. When the 7th year was up, the father said, "Let's have a wedding." And they had a wedding. I don't know whether the woman was not in the wedding. Because when you read the story, you don't hear that the woman showed up. But somehow, at that night, the woman showed up in his room. But she was behind a veil. And I believe that the man must have been drunk. You see, if you have been spying a woman for 7 years, even if she's wearing a sack, you can say that, "Oh, no, obey." 7 years, pa. So this woman shows up in his room at night. I believe they turned off the light. He didn't lift the veil and proceeded to proceed. Without lifting the veil, he did not know who was behind it. And so the next morning, when the veil was lifted, he discovered, ouch, the big sister had been given to me. I have been tricked. I have, and I can't go back. How can a man make such a mistake? Because he did not lift the veil. Because often when the veil is lifted, then you see whether what is behind the veil is actually what you've bargained for. In Ghana, Justice Yapo, in an unreported decision, Sumni Boama, defined the concept of lifting the veil. And I want to read this to you. He says there's no doubt that at least conceptually, there is a complete separation of the company from its members or directors. And that incorporation is a veil or a cloak that is generally opaque and impassable. However, the corporate entity may sometimes work like a boomerang and hit the person who is trying to use or abuse it. Over the years, inroads have been made into the near sacrosanct concept of the corporate personality, both by statute and by the courts of equity. These inroads have allowed the veil or cloak of incorporation to be lifted to look behind the corporate personality and to hold shareholders and or directors liable having regard to the realities of the situation. This approach is commonly known as lifting the veil. But does this boomerang work in Ghana? Does this ricochet work? That if you try to exploit the company, the law will disregard it and hold you responsible. Or if you try to use a series of companies to hide transactions, the law will disregard it. I say yes. But this is the thing with Ghana. And I will keep saying this. All the laws we need to regulate us have already been passed. They exist. The issue is whether we'll ever use it. We don't need any new laws, maybe just a few. We've passed all of them. We do well in passing them, but we do better in breaching them when we have passed them. And so I give this example because it's very serious. Hit by a bolt of morality and probably to meet worldwide standards, one government passed the Public Procurement Act. It says now you can't hide in a room and give a government contract. There must be open tendering. But there are two other exceptions. You can do restrictive tendering and sole sourcing. The minute we get sole sourcing, that's it. We have used it to break all the rules we put down in the Act. But there was one aspect that people didn't seem to realize. That the Procurement Act also regulated disposal of government assets. And it said you cannot dispose of government property, plant or equipment without a board of inquiry assessing the property and determining that the government no longer needs it. And if you decide to sell it, it is to the highest bidder. It must go through an auction. That's the law. Then we realized that although they had passed the law, before every transition, they were selling cars to the political actors, the users. Rumor has it that 2 years before every election, all the political actors will get new cars and park them in their garage. Rumor. So that, and the rule is that if the car is 2 years old, you get it at next to nothing. So they park it in the garage, 2 years, it's brand new old, and they buy it for next to nothing. So civil society started making noise. Civil society, those of us certified true known people. When we started making the noise, the politicians said, oh wait, the act you are talking about says property, plant, and equipment. Car is not any of them. Vehicle, no day inside. So we made noise and made noise. So everybody agreed that they will amend the law and specifically say vehicles. And so in July 2016, they amended the law and said vehicles. Now you must understand that every breach of the Public Procurement Act is a potential crime. So they passed the law. We were all happy. July 2016. Between 28 December and 6th January 2018 to 2016 to 2017, what did they do? They sold 381 cars to themselves. Same procedure. Same procedure. Without going through the law. No board of inquiry. No certification of it. Whoever was using it. I've seen the list. We know all of them. Some of them are still making noise. They bought the cars between 2,000 series and 40,000 series. 2,000 for Hyundai i10. The 40,000 I think was a BMW 7 Series. The gasps in the room are amazing. But there are legislative inroads into the concept of corporateness. For example, every company must start with a prescribed minimum. Every company must have a prescribed minimum membership, which is 1. You cannot have a company with no shareholder. At least 1. If that shareholder leaves or dies, the company must wind up within 6 months. Or else another person must buy the shares. If the company continues in business with no member, then every director will be responsible for the liabilities the company incurs. So you can't say, but we are only directors, the man died and nobody came forward. The law says that make sure that within 6 months, if nobody steps up within 6 months, you have to stop work. If you allow the company to operate for more than 6 months after the death of the only shareholder, you, the directors, will be liable for all the obligations incurred. This is lifting the veil. 2, and I love this one. It's called misdescription. The company's full name an accurate description must appear outside its registered office, head of its business letters, invoices, receipts. A company may dispense with the name company in its name, the word company. But if it is limited by shares, it can never dispense with the word limited or its abbreviation LTD. It is a misdescription. So go around and see all the banks that have their bank names without limited. It's a wrong. And if that happens, then every officer who purports to act on the company's behalf is liable to a fine. And in some instances, liability for every obligation incurred. So you see all the companies that don't use the word limited, it's usually the banks. Outside their building, the law lifts the veil. But who will apply it? Because if the word limited is used, then you understand that if you are dealing with a company, the liability of the members, if any, is limited to amount unpaid on their shares. So that when the company has paid, when the shareholders have paid for all their shares, you can't touch them. So you know how it is when you are dealing with a company, that this is limited, this is unlimited. But we don't do it. In fact, the law is so strong that in one case, the company was called South Shields Salt Water Baths Company Limited. South Shields Salt Water Baths Company Limited. In one bill, they described themselves as Salt Water Baths Company Limited, South Shields. In the other one, South Shield Water Baths Company. It was held that the real name of the company didn't appear, and so the directors were personally liable. This is as far back as 1889. More recently, 73, the company was called L&R. The L was capital L, full stop. The and is what they call the ampersand. You see that? And that is on the L&R Agencies Limited. They signed a check by writing L.R. Agencies Limited. So the ampersand was omitted. The court held that the directors were personally liable because they've ignored the connecting ampersand and that they had not used the correct name of the company. It lifted the veil and held the directors liable. Every company must have a minimum capital. I'm shy to mention the minimum capital now. It's a joke. But it used to be 2 million Ghana cedis, which is how much? Okay, so I don't even want to go there. But every company must have a minimum capital. This to ensure that the company doesn't collapse immediately it starts work. If this is breached, every officer is liable to a fine for every day that the breach continues. The directors and subscribers will be personally liable for the debts and liabilities incurred during the breach. Lifting the veil. Next one. Where it appears in the course of any official liquidation that any business of the company was carried out with intent to defraud creditors or for any other fraudulent purpose, a court may, on the application of the liquidator or other declared persons, declare that the persons who were knowingly parties to carrying on the business will be personally liable for the debts. Now, this fraud may be inferred if the company continues to carry on business and incur debts at a time when the directors know that the company has no reasonable prospect of paying its creditors. Ghana banks. So if the directors know that the company is technically insolvent, the company must stop business. If it continues in business and a debt arises, the directors, in the event of liquidation, will be held personally liable. Then if you are going to take that risk, make sure the company recovers. Because if the company does not recover and it has to go through official liquidation, you may be held personally liable for transactions you entered into at a time when you knew the company couldn't pay. Yeah, this is in our law. If you incorporate a guarantee company, and a guarantee company is what you normally call NGO, it's supposed to be non-profit making, and you use the company to make profit, all the members and officers who are aware of it are jointly and severally liable for the payment and discharging of all debts and obligations and liabilities incurred by the company, as well as a fine for every day that the illegality continues. Because the NGOs are not supposed to be used for business. So you can't say I have a guarantee company and it's constantly engaged in business. That is not allowed. If you set up a guarantee company, then you are going to use it for charity work and church work, to the extent that that is not a business. I spent this morning telling the churches about possible tax obligations. I was on my feet for about 3 hours. Now, this is to discourage unscrupulous businessmen from using the guarantee company to do business. Yes, the guarantee company may engage in some business and fundraising, but all the funds must be reinvested in the company. Where the registrar has cause to believe that a company is not fully compliant on keeping and auditing accounts, or the law is being flouted, or the business is being conducted with intent to defraud creditors, depositors are creditors. If the business of the company is being run to defraud creditors, depositors are creditors, or for any other fraudulent purpose, or persons connected with the formation or management of the company are guilty of breach of duty towards the company or its members, the registrar has the power to demand the books of the company and all explanations and information. And if the registrar is not happy, the registrar can write to the Attorney General and say that these directors have been stealing from the company. This is the evidence. Prosecute them. The registrar could also apply to the court to wind the company up. The registrar is also empowered to commence proceedings against the directors in the name of the company, in the public interest, to recover every loss that the company has incurred. These exist. And so if you are taking depositors' monies to buy properties around the globe, the registrar of companies has the power to sue you in the name of the company to recover it. Mr. Director, Madam Director of a company, if you are in breach of your fiduciary obligations and the company incurs a debt, the registrar can sue you in the name of the company and sell your assets and give it back to the company. Indeed, if the company is undergoing liquidation, the liquidator can take the action against you. If the company is under receivership, the receiver can take that action against you. If you are accepting to be a director of a company, be careful. You can't say they didn't show it to me. That is not an excuse. Because the duty of a fiduciary includes what the lawyers call uberima fide, utmost good faith. Which means you must go beyond the call of duty and ask questions. And if you sit in a board meeting and you are intoxicated with the cakes and the croissant and the donuts that are being served to you, and you are not looking through the books, and one day it is found out that you are in breach of your duty, we should sell your house in exchange for the cakes you ate and the sitting allowance. Now, particularly in taxation, the Commissioner General has many powers to disregard groups of companies. I need to move on. So if you engage in things like income splitting, and income splitting is where you form a lot of companies and transfer income and income producing property among the family members so that you reduce your taxation. For example, you run a bank and you think the bank is going to make too much money and IRS will tax it. So you form a lot of companies around your bank that provides all the services at an enhanced value so that you rack up your expenses to reduce your taxes. IRS might say that is income splitting. Nonsense, put them all back and let's tax you. Somebody said, wow, yeah. When you do what is called transfer pricing, which is where you seek to reduce your tax burden by shifting, this time, transactions through affiliates in non-arm's length way, the Commissioner General can disregard it. That is why under the Banking Act, related party transactions must get Bank of Ghana approval and it must be on commercial basis. So if you have a bank and you decide that you will set up another company to provide security for the bank, the first thing you must do is to make sure that what your other company is charging the bank is commercial. You can't do it for 3 times the value. It's a void transaction. You could get into a lot of trouble. You can't do what is called thin capitalization. Now, this is the point. I told you, if you put equity in the business, it will take a while to make dividend. But if you put debt, then you can claim interest from time to time. So what big businesses do is that they would have a very small equity and the rest will be debt. So you have thin capitalization. Now, especially when this is done by non-resident people or people who are exempt persons, Ghana law says it's a ratio of 3:1. If the debt to equity ratio exceeds 3:1, Commissioner General will say, I don't regard it. You are lying. You want to hide equity. You want to have thin capitalization of the company so that you hedge your risks and your bets on the debt. Deemed dividend. And it's very interesting. The company's made money, but you don't want to pay dividend because you don't want to pay the tax. So you are paying yourself through directors' fees, allowances, and everything. IRS can look at the company and say, this company has made money. You know, if you declare dividend, you have to pay dividend tax to us, and you are evading it. Although you haven't distributed the money, GRA says this amount of it is deemed to have been distributed. Come and pay taxes. These are just a few examples. The law has many. Now, let's deal with the last bit, the judicial inroads. Now, the courts have what is called an equitable jurisdiction to pierce the veil. And they have a lot of discretion to do justice and decide individual cases. These rules on piercing the veil have evolved from maxims of equity such as equity will not suffer a wrong to be without a remedy. He who seeks equity must do equity. He who comes to equity must come with clean hands. Equity looks to the intent, the substance, and not the form. And equity looks on as done, that which ought to be done. And so the court will lift the veil where it is established that the company is being used as an agent of its controllers. You are simply hiding behind the company as your agent to avoid certain obligations. And so in a Ghanaian case, Kuni vs. State Gold Mining Corporation, the court laid down a test, 6 tests. Are profits treated as those of the parent company? Are the persons conducting the business appointed by the parent? Is the parent the head and brain of the enterprise? Does the parent govern the business and decide what should be done? Are the profits made by the skill of the directors or by the parent company? Or is the parent in effectual control? Under those circumstances, the court said, a person causing something to be done, the doing of which casts on him a duty, cannot escape the responsibility by attaching to him, or seeing that the duty is performed by delegating it to another. Where a person is authorized by statute or bound by contract to do a particular job, he cannot escape responsibility by contracting another person to do it on his behalf. Unquote. Especially in tax cases, the courts are very willing to lift the veil. In a 1908 case, Gramophone and Typewriter versus Stanley, the English court said that the fact that an individual by himself or his nominees practically hold all the shares in a company may give him control in the sense that they may enable him to exercise his voting powers to turn out the directors and enforce his own views. But it does not in any way diminish the rights or powers of the directors to make the property and assets of the company his as distinct from the corporation's. Nor does it make any difference if he acquires absolutely the whole shares. But if he positions himself that the company is just standing in front of him for him to exploit the company, the law will look at that. If you use the company as a mere facade, the law will disregard the veil. In Amate versus Social Security Bank, Ghanaian company, Amate was the chairman and managing director. That's what we call executive chairman. Executive chairman, not chairman, chairman. And the company went for a loan from Social Security Bank, and he provided a personal guarantee and a mortgage of his house. When the company defaulted, the bank notified the company, went to court, sold his property. Then he got a lawyer. Lawyers. The lawyer sued the bank to say, under the terms of the agreement, Amate should have been given notice of the default before his house would be sold. He was not given the notice, so the court should set the sale aside. The court said, rubbish. Okay, the court didn't say rubbish, that's my word. That, yes, he was the mortgagor, but he was also the managing director and chairman. He was the one who received the notice from the bank meant for the company, that the company was in default. So is he telling us that because the envelope didn't have his name behind it, he didn't have notice? The court said, make me think. And so words like, when the company is being used as a device, a stratagem to mask realities, or is to enable a person under a cloak or sham, a device, to engage in business that will be in breach of an agreement, or where the company's role is purely colorable, which means a counterfeit, and is being used for the sole purpose to evade the law, or where the company is a device, a sham, a mask which a defendant holds in his face in an attempt to avoid recognition by the law will disregard the company. In United States versus Milwaukee, the American court held that a company will be looked at as a legal entity until sufficient reason to the company appears. However, when the notion of legal entity is used to defeat public convenience, justify wrong, protect fraud, or defend crime, the law will regard the company as just an association of persons and go after the persons. I'm concluding. The corporate form, as I've shown to you, is an invention of the law. It has huge advantages for business people, but it is an artificial person operated by human beings. It is subject to major abuses. It does not have a mouth to cry out when it's being violated. And when the banks were being violated, they couldn't cry out. But the law has not left its creature without protection. The company is an artificial person and can only act by agents. The person by whom its business is carried on and superintended are called directors. And the law says that it is their duty, they are appointed to direct and administer the business of the company. Directors are so powerful that, except as provided in the regulations, they manage the business of the company and exercise all residual powers that are not vested in the shareholders. When acting within their powers, the board is not bound to obey the instructions of the shareholders or the general meeting. If the general meeting don't like what the directors are doing, they can sack them. And even they go by a very strict procedure. For this reason, directors themselves are subject to strict rules. From sections 203 to about 210 of the Companies Act. 2 Ghanaian cases summarize them. Asafo J versus Ejekum and Dichi versus Amin Sangari. 1, fiduciary relationship. That the company is weak, you are strong. You owe duties to the weak artificial person. 2, observing utmost good faith. Like I said. 3, acting in the best interest of the company to further its businesses and promote its purposes. 4, you must not, without the consent of the company, place yourself in a position where your duties or interests conflict with the duties and interests of the company. You can get the consent, but there must be full disclosure, and you must not then take part in the decisions. If a director breaches these duties, you are liable to compensate the company for any loss resulting from the breach. And so all the directors whose names are in the reports, who sat down for breaches to occur, first line of breach, fiduciary duty, you are liable to compensate the company. So the billions of cedis we are seeing that have been lost, if the regulator, that's the company's registry, who is one of the regulators, if the receivers, the liquidators are minded, they will sue the directors personally in their own names. And if the court determines that they have breached this duty, the court will order compensation. It is called judgment debt. And then the state will move in, seize their assets, and sell them. So you may try to breach the law, but know that when the law gets you, it will show you how jealously it protects the company. My last word of caution. It is a fearful thing to fall into the hands of the law. Don't try it. Thank you very much.